Good afternoon, everyone, and thank you for joining us today for the 2026 Frederic R. and Molly S. Kellogg Biennial Lecture in Jurisprudence. I'm Aslihan Bulut, and I have the honor of serving as the Law Librarian of Congress. The Kellogg Lecture presents the most distinguished contributors to international jurisprudence, judged through writings, reputation, and broad and continuing influence on contemporary legal scholarship. We are very grateful for the generosity of Frederic R. and Molly S. Kellogg, which makes this enlightening lecture series possible. It's my pleasure to now introduce our next speaker, Frederic Rogers Kellogg. He was born in Boston and attended Harvard College and Harvard Law School. He served as an assistant U.S. attorney and later as an advisor to Attorney General Elliot L. Richardson during the Watergate crisis. He later earned a doctorate in jurisprudence at George Washington University and published 2 books on Justice Oliver Wendell Holmes. A former Fulbright Senior Scholar in Poland and Brazil, and Sir Neil McCormick Fellow at the University of Edinburgh in Scotland. He's currently a visiting professor at the Federal University of Pernambuco, Brazil. Also, just so you're aware, I wanted to note that we'll take questions at the end of the lecture, both in person and online. So at the end, if you are in person here, please raise your hand and one staff member will be coming around with a microphone. And if you're online, please type your questions into the Q&A box. And with that, I will turn it over to Fred Kellogg.
Well, welcome. Thank you for coming. This occasion has now passed its 10th year, and a little over 10 years ago, my wife and I met with the Librarian of Congress, Jim Billington, and we gave him the idea that we borrowed, actually, the idea of a lecture from Molly's cousin, Philip Bobbitt, who had initiated the Bobbitt Poetry Prize at the Library of Congress. And so it was kind of like, well, why not if you've got poetry already, maybe we should bring things down to earth. I hope not too boring. But this is the 10th year, and we're very happy to have with us as a speaker Professor Robert George of Princeton University. My father was Princeton 1932 and center on the football team. So it's great to have him. Professor George is the author of many works in jurisprudence in the subject of natural law, and an articulate defender of it in Conscience and Its Enemies, Confronting the Dogmas of Liberal Secularism. Liberal secularism is his topic today, and I can't wait. It follows 2 basic rules. First, government should not be informed by a particular religious doctrine, and second, the state should guarantee freedom of conscience of its citizens. But liberalism is challenged today like never before. Adrian Wooldridge writes that outward signs of its demise are everywhere. Keir Starmer won a mandate in 2024 only to become the most unpopular prime minister on record. In Germany, a similar fate awaits the liberal chancellor Friedrich Merz. And in France, Emmanuel Macron has discovered what an early twilight is like for a president. All this only goes to show how the jurors for the Kellogg Lecture have an uncanny talent for addressing the future before it arrives. Professor George sets forth powerful arguments that secular liberals are unaccustomed to hearing, and also lays out the principles and arguments for rebuilding a moral order. Some challenge indeed. But I have a caution from the American pragmatists, John Dewey and Oliver Wendell Holmes, Jr. I should recall their insight that principles come at the end of experience, not the beginning, a process that opens up questions yet unaddressed. How can the moral order be rebuilt in a world of new experience? This is a challenge that our speaker is uniquely equipped to meet. Still, I can't help noting one major insight to be drawn from both Dewey and Holmes, one that Dewey summarizes in just one word: the continuum, by which he means the continuing process of argumentative inquiry. Principles are not found on the shelf anywhere. They are the product of constant struggle. Right now, we are in an unsettled period, but that, for Dewey, is a perfectly normal stage in the process. It reflects that there is yet work to do, and Professor George is here to give us some much-needed guidance. So my thanks now to the jurors, Mark Medish and Don Wallace, as well as Robert Newland, Principal Deputy Librarian, Aslihan Balut, the Law Librarian of Congress, Robert Brammer, and the library staff who work on this program, and thank you all for coming.
I am immensely grateful to the Library of Congress for the opportunity to join the distinguished line of philosophers of law and moral and political philosophers who've given this distinguished Kellogg Biennial Lecture in Jurisprudence. I want to thank Librarian Ballou especially for this privilege, and the jury. I also, of course, thank Fred and Molly and the Kellogg family, not only for this opportunity for myself, but for enabling the library biennially to invite a philosopher to reflect on fundamental questions of law and justice, questions that are never out of season for citizens of a constitutional democratic republic. Now, I wish to begin my remarks, which I have provocatively entitled "Why Liberal Secularism Fails," by repeating the words with which I began my book, Making Men Moral, Civil Liberties, and Public Morality, 33 years ago. And those words are as follows: any critic of liberal moral and political thought who aspires to be in the least fair-minded must begin with a forthright acknowledgement of the genuine contributions of the liberal tradition to the identification and protection of valuable human liberties, unquote. My lecture this afternoon will say a lot about what's wrong with what, following Oxford legal philosopher and my teacher, John Finnis, I label liberal secularism. I want to begin, however, by saying a bit about what's not wrong with that tradition, and indeed what leading liberal secularist thinkers get right. But before I do that, I should also apologize for the length of this lecture. The important part comes at about 37 minutes. I'll wake you up for that. I thought about maybe giving the lecture in Hebrew so I could omit the vowels, but I thought, well, it'd be hard to understand then. Now, liberal secularists are right to accept what the late and very great liberal secularist philosopher John Rawls called the fact of reasonable pluralism. So bear that in mind, the fact of reasonable pluralism. They are right to be concerned about the stakes of politics amid pervasive disagreement on the great questions of human nature, the human good, human rights, human dignity, and human destiny, stuff that people really care about, stuff that people are sometimes prepared to fight over, not just in the metaphorical sense of fight, but even with arms. Those are high stakes if the stakes of politics include conflict over those issues. They're right to worry about those stakes. And they're right to reject and to fear and to attempt to provide guardrails against illiberalism. They're right to affirm and defend fundamental civil liberties and civil rights, such as freedom of speech, freedom of the press, freedom of religion and assembly, and the rights of due process of law and the equal protection of the laws. These rights and liberties are precious, And in certain ways, they are fragile. On these points, people today we categorize as liberals or conservatives ought to agree. These basic rights and liberties have been hard won and can easily be lost. It's not the case that if you get them, you have them forever. You can get them and lose them, which means we've all got a stake, if we believe in them as I do, for the reasons I'll articulate, protecting and preserving them. And different traditions of thought have contributed to their defense and to our understanding of them. And liberal secularism is among those traditions. Even if, as I shall argue, liberal secularism ultimately fails to provide an intellectually secure defense and satisfactory understanding of basic rights and liberties, it should be given the credit it is due. Now, my central contention in the lecture is that even the most distinguished and intellectually rigorous proponents of liberal secularism, including Professor Rawls, Jürgen Habermas, and Ronald Dworkin, the last of whom was, as it happens, another of my teachers, as well as a previous Kellogg lecturer, have failed to provide a satisfactorily normative grounding for the robust accounts of civil liberties and moral pluralism that their theories seek to defend. I'll further argue that liberal secularists pose a false dilemma when they say we must choose between, one, accepting the contemporary social reality of pluralism, and two, opening politics, policy, and law to robust debate aimed precisely at settling via constitutionally prescribed procedures of deliberative democracy issues of law and public policy about the human good and the virtuous life. So let me say a bit more about what I mean by liberal secularism. Liberal secularist theories, most of them by design, some just in effect, regard or treat as unjust any policy or constitutional design choice that is based on reasonably disputed views of fundamental questions of meaning and value. That is to say, moral and spiritual questions, questions of human nature, the human good and its transcendent significance, and moral truth and its ultimate foundation. These views would exclude reliance on such contested normative views in debates aimed at settling questions concerning, for example, church and state, how to legally define marriage, how to define male and female in law, whether to legislate against pornography or prostitution, abortion, assisted suicide and euthanasia, sports betting and other forms of gambling, recreational drugs, and so forth. These big questions that we fight so much about in our politics. Now, according to Professor Rawls, for example, it's unfair and therefore unjust to settle such questions based on what he called comprehensive doctrines. In other words, ideas drawn from systems of belief about fundamental questions of meaning and value, their sources and implications for how we human beings should lead our lives. As Rawls wrote, quote, "Which moral judgments are true, all things considered, is not a legitimate basis for crafting law and policy." And the comprehensive doctrines that Rawls would exclude as bases for policymaking, and indeed democratic deliberation, may be religious belief systems such as Islam, Judaism, Catholicism, Hinduism, Buddhism, or secular and even secularist moral frameworks such as Marxism, utilitarianism, and indeed liberalism itself, if not constrained as Rawls seeks to constrain it, to a purely political doctrine. In other words, Rawls rejects appeals to what he calls liberal comprehensive doctrine. In fact, his 1993 book, Political Liberalism, revised his famous 1971 book, A Theory of Justice, precisely because he came to believe that he had made a mistake in a theory of justice in relying on ideas drawn from liberalism considered as a comprehensive doctrine itself, that is, as a doctrine about what makes for or detracts from a valuable and morally worthy way of life. Now, the foundational challenge that liberal secularist theories of all stripes are grappling with is an entirely valid one. And liberal secularism's critics, people like myself, need to grapple with it too. That challenge, which I alluded to earlier, was described by Rawls in his 1993 book, the Political Liberalism book, as the fact of reasonable pluralism. That idea that I ask you to hold in your mind, the fact of reasonable pluralism. What is that? It's the fact, and I agree it is a fact, that in contemporary democratic societies, reasonable people of goodwill honestly disagree about questions of meaning, value, goodness, truth, and virtue. We disagree profoundly. There's wide disagreement. The society is polarized over these big questions. For example, when does life or the life of a human person begin or end? Does human life have intrinsic or merely instrumental value? How does one go about leading a good and morally worthy life? Is morality universal and objective, or is it situational and subjective? What is marriage? How is it properly defined? What are and are not sound principles of sexual ethics? Is sex itself biologically rooted and fixed, or is it a fluid matter of social construction or self-identification? As Rawls pointed out, competing answers should be expected given the ineradicable burdens of judgment we human beings bear. Big issues are hard. If you give people freedom, which you should, they're going to reach different conclusions about those big issues. That's the fact of reasonable pluralism. Now, I agree with Professor Rawls that under conditions of intellectual freedom, that is, where people enjoy liberty of thought, conscience, and religion, it's natural and to be expected that people will disagree on fundamental questions of this sort. Since such liberties are valuable, the freedom to think for yourself, the freedom to inquire, the freedom to deliberate, the freedom to judge, those are valuable freedoms. Rawls and I agree about that. We need a way to live together in peace and even to cooperate with each other as fellow citizens, despite deep disagreements about profoundly important matters. Now, I should add that how to address ineradicable disagreement is a question that has vexed our republic since its inception. This is no new question. Indeed, it's materially the same question James Madison confronted in Federalist Number 10 when he wrestled with the possible solutions to what he called the mischiefs of faction. But rather than accepting a mere modus vivendi in which the terms of civic order and political decision-making rest on a contingent agreement we make, those who take the fact of reasonable pluralism seriously, from Madison to Rawls to me, desire a principled solution that can bring forth and sustain a well-ordered and even flourishing society and a fundamentally just polity, despite the presence of deep and enduring disagreements. What's more, we eschew, Madison, Rawls, I myself, all of the figures we're going to be talking about today, eschew moral relativism or subjectivism as a ground for civil rights and liberties, and we seek to identify sound moral principles of justice for the governance of pluralistic democratic societies. So this debate that I'm using this Kellogg lecture to involve myself in is not a debate about whether there is such a thing as morality. It's a debate about what morality requires, what justice requires in a pluralistic democratic society. Now, for the most prominent forms of liberal secularism, the answer to the problem posed by the fact of reasonable pluralism is what another previous Kellogg lecturer, my friend Professor Michael Sandel of Harvard, has described as rights-oriented liberalism. The right and rights must be prior to the good and basic human goods, that is to say, constitutive aspects of human well-being and fulfillment, and must, that is, the right and rights must be identified without appeal to controversial conceptions of what makes for or detracts from a valuable and morally worthy way of life. This idea that government must not rely on controversial ideas about the human good in making policy and in designing constitutional structures, Rawls labels anti-perfectionism. It's a funny label, but he dictates the labels, so he called it anti-perfectionism. Now, the priority of the right and rights to the good and goods is essential to justice on this understanding because it is a requirement of fundamental fairness. How do we know? Well, because behind what Rawls calls a veil of ignorance, in what he calls the original position, where we know nothing about ourselves that makes us different from anyone else, including what our beliefs happen to be about what makes for a fulfilling and upright way of living, there in that original position, behind that veil, we would select for the polity we would later come out from behind the veil to be a member of, principles of justice that prohibit governments acting in ways that restrict liberty on the basis of contested conceptions of meaning and value, questions of the human good. Concretely, proponents of the most prominent forms of liberal secularism maintain that in our law and policy making, we can avoid having to take a stand on the question of whether, for instance, pornography is good or bad, morally innocent or humanly degrading. And we should, they insist, avoid taking a stand. Justice requires that we avoid taking a stand. We can have our own private opinions, but we can't embody those opinions in law. Why? Because the considerations available for resolving such a question, is pornography innocent naughtiness or is it morally, humanly degrading? The considerations available for resolving that question do not qualify as what Rawls calls public reasons. They are rather reasons of a sort that can reasonably be contested by persons who do not subscribe to the comprehensive doctrine, or one of the comprehensive doctrines, from which they are drawn. It could be religious, it could be secular, but it would have to be a comprehensive doctrine. They are not part, in other words, of what Rawls calls the overlapping consensus of norms and other principles shared by the range of reasonable comprehensive doctrines, i.e., comprehensive doctrines that are consistent with pluralistic, freedom-respecting democratic regimes. Now, none of this is to suggest that Rawls supposes that there is no truth of the matter about the validity or otherwise of moral norms and other principles contested by subscribers to competing comprehensive doctrines. Once again, it's critical to see Rawls is not relying here or appealing to moral subjectivism or moral skepticism or moral relativism. He's not denying there is a truth of the matter, as I've already suggested. He proposes his theory of justice and indeed its anti-perfectionist strictures, no drawing on ideas that represent controversial conceptions of the human good, precisely as a proposal about moral truth. He's saying this is the moral truth of the matter. In a pluralistic democracy, it is morally wrong because unjust to make laws based on controversial conceptions of the human good and personal virtue. It's a proposal about moral truth, one that centrally includes the claim that it's sometimes unjust to restrict freedom on the basis of contested ideas about moral truth, even if or when a contested idea about moral truth happens to be correct. So the fact that a proposition is true, a moral proposition is true, just take that to be an objective matter. The fact that it's true still would not mean that it's legitimate for government to act on a judgment of its truth. So the question is this: is it possible for liberal secularist theories of justice and political morality to comply themselves with their own anti-perfectionist strictures? Can Rawls make the whole machine work without himself doing what he criticized himself for doing in political liberalism, looking back on what he thought was a mistake he made in a theory of justice, that is, smuggling into the analysis ideas drawn from comprehensive liberalism, that is, liberalism considered as a comprehensive doctrine. In proposing policies and designing constitutional and other political structures, can liberal secularists avoid drawing on their comprehensive views, smuggling into their proposals liberal secularist ideas on fundamental questions of meaning and value? And can they provide solid reasons for supposing that there is something necessarily unjust in restricting liberty based on sound understandings of morality and the human good. Like Rawls, Ronald Dworkin held that a sound understanding of justice requires a commitment to anti-perfectionism. Dworkin put the matter in terms of neutrality. To be just, law and policy must be neutral on fundamental questions of the human good. In the 1980s, in a famous article defending what he described as a right to pornography, Dworkin presented that putative right as a specification of a more abstract and general right to what he called moral independence, which in turn he proposed to derive from a still more abstract and general right of people to be treated by their government with equal concern and respect. Now, far from defending pornography or a right to pornography on the ground that pornography is morally innocent or socially harmless, Professor Dworkin correctly, in my view, identified the wrong and social harm of pornography. Its widespread availability, he bluntly stated, and I quote Dworkin now, would sharply limit the ability of individuals consciously and reflectively to influence the conditions of their own and their children's development. It would limit their ability to bring about the cultural structure they think best, a structure in which sexual experience generally has dignity and beauty, without which their own and their family's sexual experience is likely to have these qualities in less degree. Unquote. Well, I couldn't agree with that more. But if all that is true, then what ground of principle could there be for claiming that people do indeed have a right to pornography, despite its bad social effects? Now, of course, there may be prudential considerations militating against some, or conceivably, though I doubt it, all forms of anti-pornography legislation. But a distinctive claim of liberal secularist theories of justice and civil liberties is that justice itself is offended by the prohibitions. It's not just a prudential concern. The prohibitions violate people's rights, in this case, a right to pornography. In other words, for Dworkin, anti-pornography legislation is wrong in principle, not merely inadvisable. Now, the steps in Professor Dworkin's argument are straightforward. The premise, widely shared by citizens of Republican democracies, including by me, is that law and government must treat citizens with equal concern and respect. Totally agree. But Dworkin argues to do that, to treat citizens with equal concern and respect, law and government must honor and recognize a right of people to moral independence. That is, a right of people to act in line with their own moral judgments, be they sound or unsound, right or wrong, on certain sorts of matters, such as consensual sexual matters. Law and government fail to treat people as equals, fail to treat people with equal concern and respect, if they embody or act on the belief that some citizens' judgments of these matters, that is, some citizens' conceptions of virtue and human well-being, even if true, are superior to the judgments of other citizens. Now, if one grants this step in the argument, well then yes, the conclusion follows that there is a right to pornography. It seems to me, however, that the rabbit goes into the hat precisely at this step. It simply doesn't follow, logically or in any other way, that in deciding on the superiority or inferiority of competing moral judgments, law and government are necessarily failing to treat persons, as opposed to moral judgments, specifically those whose judgments are disfavored by the law or who are forbidden from engaging in certain conduct they wish to engage in, like using or selling or making pornography, unequally. It's one thing to treat ideas, beliefs, judgments differently, and in that sense unequally, but that does not entail that you are thereby treating persons who hold those beliefs unequally. Professor Finnis, Dworkin's Oxford colleague and a leading critic of liberal secularism of the Rawlsian and Dworkinian anti-perfectionist sort, pointed to the problem, noting that prohibitions or restrictions on pornography, for example, quote, may manifest not contempt, but a sense of the equal worth and human dignity of those people whose conduct is outlawed precisely on the ground that it expresses a serious misconception of and actually degrades their own personal dignity, along with that of others who may be induced to share in or emulate their degradation, unquote. Now, it's worth noting that Dworkin was writing, it's back in the 1980s, long before technology, abetted by attitudinal changes and the sweeping away of anti-pornography legislation, developments that were themselves to some degree consequences of the success and prestige of liberal secularist political philosophy, created a situation in which it's nearly impossible to shield young people, including children, from pornography or to deny its massive adverse impact on people's lives and relationships and on the broader moral ecology of societies in which it flourishes. Writing before the advent of the internet, Professor Dworkin can be forgiven, it seems to me, for not foreseeing the rise of the porn culture and its consequences, though he did, as is clear from the quotation that I read just a moment ago, understand at least in broad outline that porn has harmful social consequences, damaging children in particular, making it difficult for parents to bring up children in an environment in which sexuality has dignity and beauty, and cannot plausibly these days be regarded as innocent naughtiness or purely private vice. Now, however that may be, Dworkin's advocacy of a right to pornography illustrates how a leading, indeed magisterial architect of liberal secularist political philosophy applied the principles of anti-perfectionism at the height of liberal secularism's ascendancy in the academy and academic life and the height of its influence in the culture. Now, Jürgen Habermas, another of modern liberal secularism's most celebrated and influential proponents, who died just last month at the age of 96, mirrored Professor Rawls' exclusion of comprehensive doctrines in his attempt to distinguish between what Habermas called morality as one thing and what he labeled ethics, something else, with law and policy making being concerned with the former, that is, with morality but not with ethics. For Habermas, who was a critic of Rawls on some unrelated points, ethics involves individual decisions about those contestable normative accounts of human dignity and human nature, how one sees oneself and who one would like to become, to quote him, whereas morality properly pertains only to questions that implicate what Habermas called the interests of all. So ethics, about how I should lead my own life. Morality is about the interests of all. So whether one could or should use pornography or make or distribute or profit from it involves, for Habermas, an ethical judgment, a purely private matter, how I should lead my life, about which politics, concerned with morality, that is, the interests of all, ought to have no concern and has no legitimate basis for concern. Now, but as Professor Finnis has observed, Habermas's distinction between morality and ethics has much the same role that Rawls's distinction between comprehensive doctrines and role as Rawls's distinction between comprehensive doctrines on the one side and public reasons on the other. The distinction in Habermas's case is part of what Habermas calls an ethics of discourse. And here's how he describes that ethics of discourse. It adopts the intersubjective approach, I'm quoting, of pragmatism, Dewey, Oliver Wendell Holmes, and conceives of practical discourse as a public practice of shared reciprocal perspective taking. Each individual finds himself compelled to adopt the perspective of everyone else in order to see or to test whether a proposed regulation is also acceptable from the perspective of every other person's understanding of himself and the world, unquote. Political theory, then, is fundamentally concerned with morality, not ethics. And fundamental questions of the nature, dignity, and destiny of the human person are excluded from the realm of political theory precisely because they are ethical and not moral. According to Habermas, and again I quote, ethical questions point in different directions from moral questions. The regulation of interpersonal conflicts of action resulting from opposed interests is not yet an issue. Whether I would like to be someone who, in case of an acute need, would be willing to defraud an anonymous insurance company just this one time is not a moral question, for it concerns my self-respect and possibly the respect that others show me, but not equal respect for all, and hence not the symmetrical respect that everyone should accord the integrity of all other persons," unquote. Well, Finnis has put his finger on the problem here. Quote, "The compatibility of self-respect with this dealing with the insurance company, defrauding the insurance company, which Habermas just treats as a matter of ethics, a private matter, not a public matter concerned with morality, cannot be rationally assessed without making moral judgments about, for example, the conditions on which property rights are justly respected and justly overridden, and about the injustice or otherwise of fraud, and so forth." But if that's true, if those ethical judgments themselves are intertwined with moral judgments, if moral judgments rely on ethical foundations, then the distinction between ethics and morality, as Habermas would like to marshal it, begins to collapse. Worse still, Habermas employs the distinction in a way that implicitly answers the question, much disputed in our own culture, of who is to count as within the all. When we refer to all, who is to count as the all whose interests must be taken into account in making moral judgments, while purporting to lay aside the evaluation of certain types of killing as merely ethical. The question of how to decide who counts while complying with the strictures of anti-perfectionism is a massive problem not only for Habermas, but as we shall see, for liberal secularist political philosophy generally. Writing in a law review symposium devoted to his work in legal and political philosophy, Habermas some years ago raised the questions of abortion and euthanasia as cases involving what he considers ethical judgment, not morality. Now, of course, the claim of people who oppose abortion, infanticide, and euthanasia is that just law will protect the lives of the unborn, the newly born, the congenitally cognitively impaired, those who become severely cognitively or physically disabled as a result of illness or accidents, the frail elderly, and everyone else, because justice requires respect for the fundamental interests of all, and they count as in the all. These people maintain that every human being, simply by virtue of his or her humanity, is a bearer of profound inherent and equal dignity and is, as such, entitled to the law's protection. Now, we have a big debate about that in our society. Those on the one side say no member of the human family may be excluded from the community of the commonly protected on the basis of age or size or stage of development or disability or condition of dependency or any other ground. And so the discourse, to use Habermas's term, into which people who hold those views invite their fellow citizens is precisely a discourse about the reasonableness or unreasonableness of such an exclusion. Who counts in the all? Habermas, however, speaking from his liberal secularist vantage point, speaks of, and I quote him, Catholics, for instance, suggesting that citizens are bound as a matter of morality to accept legal abortion. This is Habermas arguing, directing his speech here to Catholics, that citizens are bound as a matter of morality to accept legal abortion and euthanasia precisely because these are ethical questions, questions concerned with what's best as a way to live, and not moral questions, questions concerned with the interests of all. Indeed, he implies that morality requires this abstention by citizens who embrace the sanctity of human life ethic from acting on the basis of their, quote, ethical, unquote, judgments, not because these judgments are unsound, untrue, or in some way unreasonable. He doesn't give you an argument against the view that they hold, but simply because they count in this category of ethical. They are about how to lead a good life rather than moral, about the interests of all. Yet on what ground are the interests of, say, human beings in the embryonic or fetal stages of development, or severely cognitively disabled people, or individuals suffering from Alzheimer's disease or other dementias to be excluded from consideration? If the question is who is to count within the all, whose interests must be taken into consideration, well, that looks to me, on Habermas's classifications, as a central case of a moral question, yet he treats it as an ethical question. If that's true, then it's unclear what to make of it. What is clear is that moral questions depend on ethical judgments, judgments regarding the nature and dignity of the human person, judgments that cannot be avoided or relegated to the domain of the merely private. Now, this is not to propose here, though I've offered my opinions on the subject elsewhere, a particular answer one way or another to the question of who or whose interests should count, or to assume that the answers typically proposed by liberal secularists are wrong, though people who are familiar with my work in bioethics will know that I believe they are wrong. So it's not to resolve that issue. It's to make the point that you can't resolve that issue without taking a stand on the question, who counts as part of the all, which question itself cannot be reduced to the status of a mere ethical question concerned with how shall I live my life. So I'm here trying to make the point that liberal secularists like Professor Habermas cannot offer policy proposals on central questions in our politics while complying with their own theory's strictures requiring the exclusion of controversial fundamental beliefs, such as the belief that this or that category of human individuals count or don't count in the process of deliberation and public decision-making about what should be allowed and what should be prohibited. Now, as it happens, there is in Professor Rawls's work an almost exact parallel to Habermas's problem on this point. In Political Liberalism, the book, Rawls raises the issue of abortion in what became a famous footnote. Indeed, it's the one concrete contemporary political issue Rawls uses to illustrate application of his doctrine of public reason. He asserted, quote, as an illustration, quote, that, quote, any reasonable balancing of the political values of 1, respect for human life, 2, the ordered reproduction of political society over time, and 3, women's equality, would give a woman a duly qualified right to decide whether or not to end her pregnancy during the first trimester and perhaps beyond. For law to protect the embryonic or fetal life prohibiting or seriously restricting abortion would impose, according to Rawls, ideas drawn from a comprehensive doctrine in defiance of the strictures of political liberalism. Like Habermas, Rawls offers no argument at all as to why the developing human being should or even may be excluded from the law's protection on the basis of age or size or stage of development or location or condition of dependency. He does not argue, as my Princeton colleague Peter Singer, for example, does in defending abortion, infanticide, and euthanasia, that human beings who have not yet achieved or who have lost a certain level of cognitive functioning are not yet or are no longer persons whose interests therefore count in the formation of public policy. That's an actual argument. You may agree with it, you may disagree with it, but it's an actual argument. It proposes a standard for judging who counts in the community to be protected and who doesn't. Those who do are the ones who have achieved and then not lost a certain level of cognitive functioning. Those who don't count are those who haven't yet achieved, or those who may have achieved but have now lost a certain level of cognitive functioning. But of course, Rawls can't argue in this way by his own strictures, because to do that would be to draw on a liberal, and in Singer's case, a utilitarian comprehensive doctrine in contravention of Rawls's anti-perfectionist strictures. What's more, Rawls does not offer reasons to rebut those secular, that is, scientific and philosophical arguments, and in that sense, fully public reasons, offered by people subscribing to the sanctity of life ethic, be they religious or, as some are, secular. In the end, as Rawls himself later acknowledged, he merely expressed an opinion, not an argument. Also, like Habermas, he eventually gets round to addressing Catholics as such on the issue. There is, however, an ambiguity in what he says. It's unclear whether he's insisting, as he seemed to be in the original footnote, that a sound application of the doctrine of public reason excludes laws prohibiting abortion earlier or perhaps even later in pregnancy, and thus excludes advocacy of such laws as contrary to public reason, or merely requires that those who advocate such laws abide by democratic resolutions of the issue, even if the issue goes against them, the resolution goes against them. Here's what he actually says, so let me just quote him Some may, of course, reject a decision, as Catholics may reject a decision, to grant a right to abortion. They may present an argument in public reason for denying it and fail to win a majority. But they need not exercise the right of abortion in their own case. They can recognize the right as belonging to legitimate law and therefore do not resist it with force. To do that would be unreasonable. It would mean they're attempting to impose their own comprehensive doctrine, which a majority of their fellow citizens who follow public reason do not accept. Certainly, Catholics may, in line with public reason, continue to argue against the right of abortion. That the Church's non-public reason requires its members to follow its doctrine is perfectly consistent with honoring public reason, unquote. Now, even if we interpret that passage generously as granting that advocacy of the strict prohibition of abortion can be consistent with public reason, Rawls's admonition to, quote, Catholics, unquote, is problematic. Plenty of American Catholics and others, the vast majority of whom reject resort to violence to protect those whom they seek to protect by law, refuse to recognize the exclusion of some from the law's protection as belonging to legitimate law in the moral sense, just as Martin Luther King, in his famous letter from Birmingham jail, joined by his fellow Baptists and many other Americans, refused to recognize segregation ordinances as statutes as belonging to law, while at the same time declining to use violence against them. Rather, King and the others believed that any law excluding any class of human beings from protection is so gravely unjust as to be illegitimate in principle, and precisely as such in need of repeal or reform. Now, as I've argued in various writings, the methodologically similar forms of liberal secularism advanced by Rawls and Habermas collapse in on themselves because they both ultimately violate the rules of political morality that these thinkers themselves outline and purport to defend without ideological preferentialism or bias. What Michael Sandel says by way of criticism of Rawls, namely that he cannot escape smuggling into his theory premises drawn from a comprehensive view, namely comprehensive liberalism, a set of fundamental beliefs, including beliefs about who counts, that he happens to hold but which many other reasonable people of goodwill happen to reject, can be said with equal force by way of criticism of Habermas. The theories of political morality adumbrated by these leading architects of liberal secularism in Europe and in the Anglophone world during the period of its ascendancy run aground the same way, in my opinion. They cannot pass their theory's own test of justice and legitimacy by prescinding from fundamental questions of meaning and value, of human nature, the human good, and the dignity of the human person. Indeed, from the very question of who is a human person in resolving disputes that are central to the politics of their societies. And again, my point here is not to contest, it's a separate issue, not to contest their views of who is and who isn't a human person. It's to contest the idea that you don't need to decide who is or who isn't a human person in making law about abortion, infanticide, euthanasia, or anything in that domain. I don't see any way you can avoid drawing on some conception that will be controversial with your reasonable fellow citizens if you're to decide who's in and who's out. I want to turn now to the ideas of an important thinker in the era of the ascendancy of liberal secularism, who, though a liberal and not, as far as I'm aware, a religious believer, challenged what might be called orthodox liberal secularism and challenged it in a profound way. Joseph Raz's magisterial 1986 book, The Morality of Freedom, published during a period in which Rawlsian liberalism dominated academic political philosophy and was held up as the standard of modern liberal political thought, constitutes, to my mind, a flagship text of what is commonly called perfectionist liberalism. This view, while rejecting orthodox academic liberalism's anti-perfectionism, nevertheless attaches a profound degree of importance to persons' maximally unencumbered exercise of personal autonomy and individual liberty as goods in themselves. So, though not anti-perfectionist, Raz's theory, with its central focus on autonomy and its importance, was liberal. Raz, who was another of my teachers and who was also a Kellogg lecturer, criticized those among his fellow liberals who assumed that theories of political morality that place goods prior to rights and seek to ground rights in the goods they uphold and serve necessarily involve, quote, a coercive imposition of a lifestyle. In his judgment, for government to base law and policy on judgments about even the most fundamental questions regarding the human good is not unjust. To the contrary, doing so fulfills the basic purpose of political action, which Raz described as, and I'm quoting him, enabling individuals to pursue valid conceptions of the good and discouraging them from pursuing evil or empty ones. So you can see that Razian perfectionist liberalism is very distant from Rawlsian anti-perfectionist liberalism. Raz wants to engage the question, what is a valid, morally worthy way of life? Let's make laws with that in mind. Rawls wants to say, we cannot get into the question, we must not get into the question, it would be unfair to get into the question of what makes for or detracts from a morally valuable way of life. But for Raz, the catch, and this is what qualifies his theory as liberal, not only in the classical sense of that term, but in the contemporary sense, is that personal autonomy is for him the preeminent political value. And it's conceived by him not merely as instrumentally valuable, or as valuable as a necessary or desirable condition for the realization of other valuable ends. No, he conceives it as intrinsically valuable, something intelligibly worthwhile for its own sake, a basic aspect of human well-being and fulfillment. Raz explains that the ruling idea, I'm quoting him, behind the ideal of personal autonomy is that people should make their own lives, and that personal autonomy is the vision of people controlling, to some degree, their own destiny, fashioning it through successive decisions throughout their lives, unquote. For Raz, the ability of people to be the principal authors of their own lives, to define themselves, their core beliefs, their identity and identity-forming commitments, and to consequently pursue a life of self-authorship, self-determination to the maximum degree possible, so long as you're not harming others, is something that a perfectionist state should honor and protect. Now, Raz is right, in my view, to embrace perfectionism. I'm on his side of that. Just as he's right, I think, to think of autonomy as, at least in some very important respects, something valuable, indeed indispensable to a flourishing life, and therefore something to be honored and protected. So far, my old teacher and I are right in line, and we're over on the other side of a divide with Professors Habermas and Dworkin and Rawls. The question between Raz and me is whether he's right that autonomy is the preeminent political value, and whether he's right to conceive it as something intrinsically and not merely instrumentally valuable or valuable as a condition for the realization of other goods. I don't think he's quite right about either of those things, but he's not completely wrong, in my view, either. So it's complicated. The key thing just at the moment is to understand that the debate here is a debate about an aspect of the nature of the human good. It's a debate that, far from bracketing the great questions of meaning and value and ruling them out of bounds for purposes of democratic deliberation, which is what Rawls and Habermas and Dworkin want to do, he wants to engage them, and I want to engage them. I don't think we can avoid engaging them. I think if we pretend to avoid engaging them, we're just going to smuggle them in and not recognize or not admit that that's what we're doing. In this sense, though Raz is a secular person and a liberal, he's not advancing an orthodox liberal secularist position. In a long-running debate that we carried on from the days when Professor Raz was co-supervising my doctoral dissertation at Oxford until his death decades later, I contended against my revered teacher that autonomy, though important and indeed in some ways indispensable for human flourishing, and though sometimes needing to be given its proper place in theories of, though it's something needing to be given its proper place in theories of justice and civil liberties, it's still not something to be prioritized over other important values, nor is it properly conceived as something intrinsically valuable. Rather, I argued, it had its value, autonomy had its value, has its value, and its importance, precisely as a condition for the realization of other values. Above all, those values, known to philosophers as reflexive values, in which the very realization of the value requires the free choosing of the value. You can only realize or participate in the value if you freely choose to do so. Some examples are friendship, marriage, and virtue itself, or what natural law theorists in the tradition of Aristotle call practical reasonableness. Thinking about what to do in order to be upright and doing it. Now, it's always seemed to me that if autonomy were intrinsically valuable, as Professor Raz supposed, we would have to conclude that at least something of value is realized, however wrongfully and totally unjustifiably, in immoral and even grossly wicked choices, insofar as they were made autonomously and therefore realize the good of autonomy. Whatever else is to be said against them, and this is not to justify them, but we would still have to say, if autonomy is intrinsically valuable, that the wicked choice, bad, shouldn't do it, not justified, but it did produce the good of autonomy. But such a conclusion, it seems to me, can't possibly be true. No one would say that something of value was realized or instantiated, even if morally wrongfully and utterly unjustifiably, in the autonomous choices of Hitler or Stalin to commit mass murder. The autonomous nature of such evildoing yields nothing of worth. Raz, however, maintained that though autonomy is intrinsically valuable, because he recognizes this problem that I'm presenting, he says, though it's intrinsically valuable, it's simply valueless when exercised in pursuit of evil means. But this strikes me as misconceiving intrinsic value. Take a different case of intrinsic value, namely the value of life itself, the life of an individual human being. Let's say a human being we all agree is a human being with dignity and a right to life. So let's say a man, desperate to find a transplantable heart to save his daughter, who will otherwise die of heart failure, does the heinous, utterly unjustified deed of kidnapping his neighbor's daughter and arranging for a corrupt surgeon to remove her heart, thus killing her, and transplanting it into his own daughter. Now, he has done something morally wrong, indeed unspeakably evil. There is no justification for it. There can be no justification for it. And yet, if he is successful, the life of his daughter, extended by the immorally obtained heart transplant, remains intrinsically valuable. Indeed, no one would say that her life has any less value than it would otherwise have as a result of her father's evildoing, which is not to say that the evildoing can in any way be justified. It's only to say that when you look at the whole picture, the life, the value of the life, the intrinsic value of the life of the young girl remains, despite the wicked means used by her father to preserve her life. Now, reflection on the difference between the two cases, the father and the corrupt surgeon and their evildoing, and Hitler and Stalin and their evildoing, but autonomous evildoing. Reflection on the two cases should, in my opinion, prompt the judgment that autonomy is, in truth, not something intrinsically valuable, but rather has its value as a condition, sometimes indeed an indispensable condition, of the realization of other goods, goods that are more fundamental and foundational than autonomy itself, which is not to say that autonomy is not important. On the contrary, if the goods whose realization it makes possible are vitally important, it is itself vitally important, but not preeminent. So this is where I say Raz is not completely wrong. He and I agree that autonomy is critically important. We disagree about whether it is intrinsically valuable and is the preeminent political value. Raz's autonomy-focused account of political morality has as its centerpiece a modified version of John Stuart Mill's famous harm principle, the principle that a person's actions can justly be restricted only to prevent more or less direct harm to others. The harm principle is a core doctrine of various forms of liberalism. It essentially forbids the state from enacting and enforcing legislation limiting the individual's autonomy or liberty to engage in or commercially exploit many morally unworthy acts for the sake of protecting public morality, considered precisely as the social milieu, the moral ecology that facilitates and encourages virtuous conduct and prohibits or discourages the grosser forms of vice. What Dworkin called that cultural structure, which is damaged by pornography because it harms the ability of parents and children to have dignity and beauty in their sexuality. Raz, far from being a moral relativist and firmly opposed to state neutrality about controversial questions of good and evil and right and wrong, agrees that government has a role to play in opposing the proliferation of immoral activities. Still, he holds that a due regard for autonomy's preeminent status prohibits government from criminalizing allegedly harmless or victimless behaviors. Thus, under the strictures of Razian liberalism, government regulation of, say, pornography or assisted suicide would be difficult, but perhaps not impossible, but at least difficult to justify, and would likely be considered unjustly violative of a person's efforts to be the author of his or her own life. Raz would probably hold that it's morally acceptable to discourage by non-coercive means, say the use of pornography or someone committing suicide, but you can't make pornography illegal or assisting in suicide illegal. Well, as I mentioned at the beginning of these reflections, a morally sound alternative to liberal secularism retains an appreciation of individual liberty and acknowledges the important role that freedom or autonomy plays in enabling individuals to responsibly exercise their capacities for rational inquiry, deliberation, and judgment in the pursuit of morally worthy ideas. But my thesis differs from contemporary liberal approaches to political morality, including the unorthodox liberalism of Joseph Raz, in its foundations. It seems to me that when we reason from authentic human goods and what might be called their integral directiveness, when we can then arrive at a sounder and sturdier basis than liberal secularism, even at its best, can provide for identifying, understanding, honoring, and protecting basic rights and liberties: freedom of speech, freedom of the press, freedom of religion, freedom of assembly, the right to petition the government for redress of grievances, due process, equal protection. When we start with genuine intrinsic goods, the basic aspects of human well-being and fulfillment, and proceed from there to identifying rights, we can come to grasp a sound reason for valuing pluralism and conditions of freedom. We see that while moral disagreement is indeed an ineradicable fact under conditions of valuable freedom, a fact that must be reckoned with, Rawls's fact of reasonable pluralism, moral disagreement is not itself something desirable. What is valuable is the freedom that makes moral disagreement an ineradicable fact. But the value of that freedom is itself instrumental and conditional, not intrinsic. Its value is in its service to the realization of genuinely intrinsic goods, genuine aspects of human well-being and fulfillment, such as the pursuit and attainment of truth across the domains of practical and theoretical inquiry, the establishment and maintenance of friendships and other inherently valuable forms of human relationship, including valuable forms of cooperation, as in the establishment and maintenance of republican government, the creation and appreciation of beauty, and the exploration in the arts, poetry, literature, and the humanities of meaning, the development of talent in various forms of skillful performance, the cultivation of virtue and excellence of character. These are the intrinsically valuable ends served by honorable liberty, served by autonomy in Raz's sense. The freedom to pursue such goods is, in my view, the essence of civil liberty. It is the freedom the American founders had in mind when they distinguished genuine liberty from what they called license, or what in the 19th century John Henry Newman would describe as self-will, that is, pursuing the gratification of one's desires, whatever they happen to be. To all of this, one must add recognition of the morally worthy enterprise of choosing between and among the multiplicity of basic human goods and the countless ways that human persons can uprightly and honorably act to instantiate those goods in their lives, and instantiate them in ways that make their lives hang together coherently and with integrity. Here, too, civil liberties The freedoms of speech and religion and association especially are essential. And it goes without saying that good government, accountable government, and the protection against tyranny, irrespective of the particular form of government, any form of government can degenerate into tyranny, including democratic government. It was a democracy that killed Socrates. Require limitations on the reach of government power, respect for the autonomy, authority, and integrity of key non-governmental institutions of civil society, beginning with the family, and protection for basic civil liberties, especially those of speech, press, religion, assembly, according anyone and everyone accused of a crime, due process of law, according everyone the law's equal protections. Pluralistic perfectionism, as I call the natural law and natural rights view I'm here advancing, is similar to Razian liberal perfectionism in that it recognizes that there are incompatible but nonetheless morally worthy ways of life, and that human goods are instantiated in diverse and often incommensurable ways in people's lives. Morally worthy choosing is by its very definition reasoned deliberation. And reasoned deliberation, what I called earlier, following Aristotle, practical reasonableness, is indeed something intrinsically valuable and not merely a condition for the realization of other values. A person who genuinely reasons, who self-critically assesses the options and seeks to live virtuously, even when that means resisting wayward impulses and desires and doing the right thing, or at least a right thing, because it's right, in his or her best judgment, fulfills a basic human capacity and cultivates certain virtues. It seems to me then that it is practical reasonableness, that process that I just described, rather than autonomy, the mere absence of constraint, that is the inherently enriching thing, the intrinsic value, that Professor Raz was trying to put his finger on when he identified autonomy, but only when it's used in a morally upright way, as intrinsically valuable. Now, having said all that, I must acknowledge the following. It's true that the recognition of basic civil liberties, or the limitation of regulation for the sake of protecting choices among diverse, morally legitimate options, will sometimes have the effect of immunizing morally bad conduct from prohibition or restriction. Liberty, as our founders observed, can and will sometimes be abused. Neo-Nazis and Klansmen, for example, abuse their freedom of speech to spread bigotry and hatred. That doesn't mean we should abolish freedom of speech. We need to recognize that it will be abused, and we have to tolerate those abuses. Why? Well, the great medieval Aristotelian St. Thomas Aquinas put his finger on the answer. Human law, he said, and I quote, cannot punish or forbid all evil deeds, since while aiming at doing away with all evils, it would do away with many good things and would hinder the advance of the common good, unquote. If you restrict the Nazis and the Klansmen's freedom of speech, you will not be able to protect the freedom of speech of honorable citizens debating issues on which reasonable people disagree. When political communities decide to establish and maintain civic structures or a political order that limits the state's coercive power through the guarantees of civil liberties, they're at least ideally doing what they judge will best establish conditions for virtuous citizens and healthy families and other valuable institutions of civil society to flourish. They do not intend that anyone abuse his or her legitimate freedom, though they know that there will be some people who do abuse it. They accept that as the price of creating the conditions for the flourishing of the people they serve. When our founding fathers decided they would add and the American people who ratified decided they would add the First Amendment's freedom of speech protection, they realized some people are going to use their freedom of speech for bad stuff. But they thought that the good to be achieved by freedom of speech, indispensably, you can't do without it, justified tolerating abuses. Now, I'm sure I'm not breaking any news in noting that critics of liberal secularism, like me, are not all on the same page about the breadth of liberal secularism's flaws or what should be proposed as the best alternative to it. Indeed, in recent years, we've seen intellectual and political movements describing themselves sometimes as post-liberal emerge. movements that oppose not just academic liberal theories of the Rawlsian, Dworkinian, Habermasian, and Rosian sort, but also opposing the foundational small L liberal political institutions and constitutional structures of our shared civic order, structures that some post-liberals argue have enabled proponents of liberal secularist ideologies to run roughshod in attaining legislative, regulatory, and judicial victories. Positioning themselves as a more muscular and contemporarily relevant alternative to traditional conservatism, that is, as people who, as they say, know what time it is, some, not all, I don't want to sweep with too broad a brush here, let me be clear, some self-identified post-liberals seek to dramatically expand government's role in regulating individual decision-making, restricting long-established civil liberties such as freedom of religion and freedom of speech. The alternatives to liberal secularism they propose sometimes veer into, indeed sometimes enthusiastically embrace, forms of illiberalism. An admittedly extreme example is this. I happened to view online just a couple of days ago a video interview of a writer I wasn't familiar with, but who was apparently a prominent and respected writer, novelist, named James Howard Kunstler, who I listened to suggest that it might be necessary for President Trump to ban the Democratic Party, suspend the civil courts, and establish military tribunals to replace them. That is illiberalism. As Ryan Anderson and I have noted, many of those seeking to respond to liberal secularism by overturning our established constitutional and political order, even if they don't go to the extremes of Mr. Kunstler, and most do not, throw the baby out with the bathwater in their skepticism about the utility or validity of concepts such as freedom of speech, freedom of religion, the separation of church and state, even in the modest, not extravagant sense of separating the institutions of religion from the institutions of government, which you don't have to be a secularist to favor, and other classic Bill of Rights type protections or principles. They see how these concepts can be misused when misinterpreted or incorrectly philosophically grounded, and that they can do damage to the common good, but they fail to see that when understood correctly at a political and cultural level, these civil liberties, these basic rights, are the concrete political support structures of conditions necessary for persons to engage in truth-seeking, for example, to grow in virtue, to practice authentic and not coerced religious faith, order their lives coherently, and pursue human goods authentically and with integrity according to the particular circumstances of their lives. That's why we should stand firm for civil liberties. On the religious front, post-liberal proponents of a closely entwined relationship between throne and altar, and advocates of state coercion in religious matters, discount how in a person's pursuit of the good of religion, it is a sincere and earnest quest for existential and transcendent truth that constitute their first steps in participating in that important human good. From the first pondering of questions like, why is there something rather than nothing? Or is there a transcendent source of meaning and value? Or is this world all there is? Or does my life have purpose? All the way to radical moments of religious conversion, growth in virtue, and as those who are believers acknowledge the deepening of one's relationship with God, are instantiated every step of the way. Religious coercion or imposition shatters the necessary process of authentic truth-seeking, elicits disingenuous conversions based more on fear or on social or economic incentives rather than a genuine desire to know and live the truth. And it causes scandal to honest religious searchers and others whose human nature inclines them toward curiosity about the great questions and mysteries of human existence. Thus, if liberal secularism fails to properly understand the nature and basis of fundamental civil rights and liberties and fails to provide for them an intellectually and morally secure grounding, illiberalism, be it religious or itself secularist, fails to grasp the value and importance of basic civil rights and liberties. In America, our founders' prudent choice was to protect fundamental rights and liberties primarily by way of constitutional structural constraints on power. That's what the Constitution primarily is. It establishes institutions for the carrying out of functions, and it limits and checks and renders accountable the power of those institutions. Our founders divided authority between a national government as a government of delegated and enumerated and therefore limited powers, and states as governments of general jurisdiction exercising plenary authority subject to certain constitutional prohibitions. Those of you who've been to law school or studied the common law tradition will know that those plenary powers are summed up as the powers to protect public health, safety, and morals and advance the common good. What's more, our founders separated powers to ensure that no one and no institution holds unchecked power or unaccountable power or power concentrated entirely in one person or one institution's hands. Our politicians aren't always so good at actually living by the rules, but them's the rules. Soon after the ratification of the original Constitution, of course, we added a Bill of Rights, and later rights-protecting amendments were added that shielded people from abuses by the states at the state level. The original Bill of Rights ran only against the national government. Well, any just society will respect and protect basic rights and liberties, but a different country, even a different democratic country, might be better served by a different constitution, one that perhaps doesn't include principles of federalism, or the separation of powers, or even a Bill of Rights. There's no single uniquely correct or uniquely just form of government or constitutional system, though there are many forms of government that are unjust, often because they systematically violate or fail to protect people's civil rights and liberties. Sometimes their justification for the failure is secular, as in China. Sometimes it's religious, as in Iran. Contrary to what some post-liberals believe, nothing in our founding or our Constitution or our civic order more broadly leads inexorably to liberal secularism. By embracing freedom of religion, of speech, of assembly, the rights to due process and equal protection, we did not buy into irreligion or religious indifferentism or to the moral relativism or expressive individualism that really does undermine and enervate fundamental institutions of civil society and abet selfishness and licentiousness. The seeds of 1968 were not, as some post-liberals say, planted in 1776 or 1787. Our nation was indeed founded on a principle that confounds any secularist ideology, liberal or otherwise. That is the principle of God-given equal dignity and natural rights, the belief that our fundamental dignity and basic liberties are not granted to us by kings or presidents or parliaments or congresses or courts or any other merely human powers. They are rather endowments from a divine creator who favors our flourishing and wills what is supportive of it and conducive to it. Since no merely human power conferred our dignity or liberties, no such power may legitimately violate them or take them away. The justifying purpose and the solemn duty of human authority, rather, is to protect and respect them. We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments were instituted among men. While the Constitution, which was ratified a little more than a decade after the Declaration, does not make reference to the source of the fundamental rights and liberties it's designed to protect, it makes sense against the background understanding set forth in the Declaration. Indeed, it's best understood as establishing institutions and constraints on the powers of those institutions to effectuate the principles and aims of the Declaration. I sometimes say, and all analogies limp, of course, but I sometimes say that the Declaration is the software, the Constitution's the hardware. That's what accounts for John Adams' famous statement that, quote, "Our Constitution was made for a moral and religious people. It is wholly inadequate to the government of any other," unquote. It's important to see, however, that in rejecting liberal secularism as an ideological framework or political morality, we needn't and shouldn't, nor did Adams and the other founders think we should, embrace sectarianism, religious establishmentarianism, theocracy, or illiberalism of any type. We would do well today to recall and to revive the founders' crucial distinction between liberty and license. We may disagree, indeed often these days we do disagree, on what is authentic liberty and what is mere license, but we can survive those deep differences, even on profoundly important moral questions. We can deal with the fact of reasonable pluralism if we look for our unity and strength in a shared commitment to the Declaration and the Constitution. Given the depth and importance of our national disagreements, the stakes of politics are indeed high. I understand why liberal secularists of the Rawlsian and Habermasian and Dworkinian school wanted to lower them, tried to find a way to lower them. High-stakes politics is a dangerous game. Still, they can't be lowered. But they need not destroy us. And they won't if we hold to the principles of the Declaration and the Constitution, to what Lincoln called our ancient faith. Thank you. Thank you. Well, thank you. I really, really very much appreciate that really generous applause, but I even more appreciate your patience with my very, very long lecture. My students sitting here may be accustomed to it, but I'm sure it's something new for others who are here. I think we're opening the floor to 3 questions. Is that right, from the floor? We might not have time for that, right?
Yeah, we're going to take some questions, so if you have any, please just raise your hand and I'll bring the microphone over to you.
Yeah. I always like students to ask questions, so if any of the students yeah, okay, Roberto Lackner here from Princeton.
All right, well, thank you, Professor, for this great talk and for inviting us down here from New Jersey to a warmer part of the country. So I have a question about something you mentioned earlier on in the talk, which was this idea that in the context of Dworkin's success with secular liberalism, a consequence of that is that you get repealment of some anti-pornography laws, and it's laxer. And I like that idea because, you know, it's not like you see politicians up there with posters and campaigns that say secular liberalism is right and Dworkin's right, and so we're going to repeal these laws, but it's the idea that this idea is in the water, so it maybe influences them.
Yeah.
So what do you think is the dominant political philosophy in the waters that is influencing political discourse today? Is it still secular liberalism? Is it maybe that post-liberalism you mentioned? What do you think it is, and where do we see it?
What a great question, Roberto. Thank you for answering. You must have a great teacher. No, I'll tell you, you know, when I was coming through, let's begin with the academy. We'll begin with university life because, you know, ideas in the academy just don't stay in the academy. They wash out and into the, I mean, if you look at the Warren era jurisprudence, it reflects an awful lot of what's going on, not only in the legal academy, but in the academy more broadly, including the decisions that made it more and more difficult to actually have effective anti-pornography legislation and other things. So let's begin with the academy. When I was coming through, when I was your age, liberal secularism of the Rawlsian Dworkinian sort was just ascendant. I mean, it was you were presumed a liberal secularist until proven otherwise, because, you know, your teachers were, most of the doctoral students were, you know, the smart undergraduates were, and so forth. Now, there were dissenters. I was one myself when I was your age. And there were others. There were figures in the academy, Harvey Mansfield at Harvard famously, Leon Cass at the University of Chicago, and there were others. But the most of those dissenters represented a form of dissent that did not veer into what we would today call post-liberalism. They represented an affirmation of the ancient faith, but reading the Constitution and reading the American civic tradition in a way that was really quite different from what the mainstream reading was at that point. Today, there is much more diversity. The ascendancy of liberal secularism is now gone. It's still represented, obviously, prominently in the academy, but it enjoys nothing like the ascendancy that it once had. And you have a much wider spectrum of views. Now, you might say, well, that's a good thing. You know, the more views in the academy, and to some extent that's true. Like I love having really wild colleagues in the academy who my colleagues think I'm one of them, one of those types, who put really, really wild ideas onto the table. You know that I disagree very strongly on bioethical questions with Professor Singer, whose ideas I think really are very wild. But I love having him in the academy because I think the educational mission is very much advanced by having all ideas on the table, by having radical ideas introduced, by having to think through the challenges that somebody who's defending an idea that really challenges your beliefs all the way down to the core, you benefit from engaging with that. The trouble is, like, what's on the table now is very, very wide, not only in the academy now, but in the broader culture. And people are buying into these ideas. Respectable people are advocating things. They might not go as far as Mr. Kunstler, you know, ban the Democratic Party, replace the civil courts with military courts, but they're really questioning basic civil liberties. And on the left side of the equation, you had very similar assaults on basic civil liberties during the Great Awakening and the high woke period. Ideas that scandalized the old school liberals who were dominant when I was in college and graduate school. So we replaced a situation where there are the old school liberals and then the dissenting conservatives, the small number of dissenting conservatives, to a situation where you've got some really, really woke people taking very extreme positions and getting quite a following on one side, and very, very, I don't think the right word is conservative, but people who really doubt whether it's a good idea to have the fundamental liberties in place that are protected in our civic order by our Constitution. You have a questioning of whether that kind of traditional American civil liberty is even a good idea. So we've got a more radical kind of pluralism, and you can't just assume that something toward the center is necessarily going to win. You know, crises happen, tragedies happen. It could be an economic catastrophe. It could be a war gone wrong. It could be a natural disaster of some sort. The circumstances created by the new technologies, by AI and other things. New technologies being used by terrorist drones, things like that could lead to a rise of a passion. Could be a passion from the left. It could be a passion from the right that would cause people to say, yeah, you know, we're just going to have to sacrifice these old-fashioned civil liberties. They don't work. They don't work anymore. We can do away with them. We don't need them. We need this other thing. We need protection. We need security. We need to get out of this mess. Somebody's got to do something to our enemies. Our enemies are traitors, all that kind of stuff. So I worry. In a certain sense, I do want to play within the 40-yard lines. It's a bad analogy because then if you play within the 40-yard lines, nobody ever wins a goal. I get that. And scores a goal. But I think we're in a dangerous situation because of the extreme nature of the polarization. It's not 1861, but it is 1800. And the country was in very serious danger in 1800. It wasn't at all clear that the country would survive the election of 1800 with its Republican civic order in place. Yes, sir.
Oh.
I have a dilemma I'm going to ask you about it, but first I'm going to recommend a book. It's called Furious Minds.
Oh, Furious Minds, yeah. Mm-hmm.
It's about sort of the extreme right.
Yeah.
I think that's the way she's not loved, but it's a very good book, very reasonable. Here's my dilemma. Listen to me. On the one hand, I believe in progress, reasonable otherwise. On the other hand, I'm a perfectionist. Now we get to say liberal pluralism includes the pursuit of truth. What if the pursuit of truth leads you to be a perfectionist and leads you to a
Yeah.
with a comprehensive set of rules?
Yeah. So the classic perfectionist argument, which I think is sound for the pursuit of truth, is the one given by John Stuart Mill, the great 19th century English philosopher and man of letters, himself a secular person. a secularist person, actually. And his argument was this: we need freedom of speech if we are to pursue the truth because of our human fallibility. We all know that we have whatever sound correct ideas we have in our heads. We all know we have some false ideas in our heads. Now, if nobody has the freedom to challenge the false ideas in our heads, then we will always be reinforced in what we believe, which will include being reinforced in the false beliefs and the true beliefs that we have, but will also be reinforced in the false beliefs we have, and will make no progress in the domain of truth-seeking. You need freedom of speech, freedom of what he calls thought and discussion. It's the second chapter of On Liberty. For truth-seeking, in the same way a human body or any animal needs oxygen in order to have life. So the relationship between free speech and truth-seeking is that free speech is a condition for the pursuit of truth. Mill proposed what he famously, or has come to be known as Mill's trident. That is, if you and I have a disagreement, there are a limited range of possibilities. You could be 100% right and I could be 100% wrong. You could be partially right but partially wrong. I could be partially wrong but partially right. You could be 100% wrong and I could be 100% right. If the truth of the matter is you're 100% right and I'm 100% wrong, then I've got really good reasons for protecting and honoring your freedom of speech, because unless I let you speak, I'm going to be stuck in error forever. I need you to have freedom in order to challenge me. If you're even if you're partially wrong, if you're partially right, I still need you to have freedom of speech if I'm to correct my partial error and get myself to the fullness of truth. The hard case, Mill says, is the third case. What if I'm 100% right and you're 100% wrong? Why should I respect your freedom of speech? And here he makes a really profound point. It's one thing to know that something is the case, so you can check the right box on an SAT type test, but it's another thing, and a deeper thing, and a better thing to know not only that something is the case, but why it is the case, how it is the case, what the significance is of its being the case, how it relates to other things that may be the case. So if I'm engaging your arguments, even if you're making arguments, intelligent arguments, but for a totally 100% mistaken position, in having to wrestle with your arguments, I will deepen my understanding of the truth that I already have in my head, but which I could deepen my understanding and appreciation of. So the perfection, that is knowledge of truth, that we're seeking, an intrinsic fulfillment of the human being, is served by the right, the freedom of speech, without which I'm going to just be stuck in error.
Thank you. I apologize. We ran out of time for questions, but
that was
thank
my
you.
fault.
No, it's okay. Thank you all for your questions. Thank you, Dr. George.
Well, thank you so much, Dr. George, for this thought-provoking lecture. I'm sorry we ran out of time. I'm sure there were more questions, including online. I want to thank everyone here. I want to especially thank, once again, Molly and Fred Kellogg for making this lecture possible. We are so pleased that you all could join us today. And please visit us online on our website, law.gov, where you can learn much more about our collections, services, and upcoming events and webinars. And also for those of you who are here in person, please join us for some refreshments in the back of the room. Thank you all so very much.